Oh, everybody got quiet. All right. All right, we're about to get started. We got quite a few bills to go through, but I expect they may go fairly quick. And I'll call on the Vice Chair to give us an invocation, please.
Let us pray. Dear Lord, we lift up the family, the friends, the colleagues of the state trooper who lost his life today. We pray for all of them. Pray for comfort in this time. Pray that you'll bless this proceeding, and thank you for our strong judiciary and rule of law in the state of Georgia. In your name we pray, amen.
Amen. Thank you. All right, to get us started, we're going to start out with House Bill 1267 and H.R. 598. We're going to do both together. We'll vote on them separately, but they'll take the testimony because they're akin to each other. So, Chairman Martin.
I don't need that computer, Mr. Chairman, but I'll take one of the chairs by it. Mr. Chairman, do you mind if I have
Not at all.
one of the council?
Sure.
As many of y'all know that have served down here with me for years, I'm several semesters shy of a law degree. But I do. I sincerely thank the committee this afternoon. I'm going to be as brief as I can in explaining this, to explain what we're trying to do, but stand ready to answer any questions. I just want to be respectful of the committee's time, and I want to thank the Vice Chairman Reeves for the prayer and the fact that we lost another trooper today. I mean, we should all be thankful for the time that we have on the planet and the sacrifices that those folks make for us. I am thankful for that. We have before you two items today that are necessary. The constitutional amendment is H.R. 598, and the enabling legislation is 1267. Ladies and gentlemen, what we're trying to do here, or what we're seeking to do, is move what is now referred to as the tax tribunal. I think it changes its name into a court, the tax court, into the judiciary branch. And if I could, just in layman's terms, the reason for looking to do that is because with the court attached to the executive branch, the first appeal of that, whether it's the state or the taxpayer, goes to Fulton Superior Court. And regardless, this bill is not indicative of the Fulton County people on the Fulton County bench doing a good job or not, but a Superior Court is really not built to be an appellate branch, from what I've come to understand. And the Fulton County Superior Court is very busy. So what we seek to do is move this to the judicial branch, where the first level of appeal would be the Court of Appeals. I think for those on the committee that are attorneys know that you're only guaranteed one appeal in the state. So when the taxpayer or the state appeals to the Superior Court, oftentimes, and I am familiar with at least one situation where it was a bench trial arguments for the day, the judge ruled from the bench, I'm not an expert in tax, we're going to uphold the decision, you can take your bite at appeals court. The problem with that is that then becomes a discretionary appeal. Now, our courts appeals courts doing a great job. They tend to give people their second bite at the apple on appeal, but that's not, it's not required by law, and it just serves to fully further back up the Fulton County bench with doing that. So with that, Mr. Chairman, again, we have a constitutional amendment that is timely because we need to do this, this year. It can only be done every 2 years. We have enabling legislation, but it would affect this change in January of 2026. The colleague with me here can get into the details of the enabling legislation, but I think the bill is so long because it has a lot of cross references. So if I could, I would like to answer any questions about where the bill came from, any further details about why I feel it's necessary, and then go with your guidance for the level of detail you'd like from Ms. Rankin.
Before we move on, I do want to recognize the judicial branch that is here today. We have a Court of Appeals Judge, Sarah Doyle, over here in the corner.
Boy, I'm glad I said nice things about the appeals branch. I didn't see her honor back there.
We have Brenda Weaver from the Appalachian Circuit back here. Bert Guy, where are you at, Bert? There you are. And Layla Zahn, who I haven't seen in years. Good to have you here. All right. So, is it up You want her to testify?
Well, it's entirely up to you, Mr. Chairman. If there's questions about the impetus of where it came from, I'd be happy to answer that. She can address the specifics of I think the constitutional amendment is to you today by substitute with your feedback. So we believe that works correctly.
Right.
And then,
for the folks out there, let's make sure we got the right one. I've got LC. This is on HR 598. LC 481215S.
that is correct.
All right. And then on the enabling legislation, House Bill 1267. This is LC 442708.
That is correct, sir. Yes, sir.
Okay. All right.
So she can absolutely give further the testimony on exactly what's being done in House Bill 1267, or I would stand for questions.
All right. I show no questions at this time, but if there's anything about the legislation you'd like to tell us, go right ahead.
Thank you, Mr. Chairman. My name is Alla Rakin. I am an attorney at Evershed Sutherland here in Atlanta. I regularly practice before the current Georgia Tax Tribunal, and I don't have any testimony, but I am here if you all have any questions about it.
All right. All right. Seeing no questions, what's the will of the committee? Well, let's break it up before we do that. Let's take up the constitutional amendment first, HR 598. Got a motion and a second. Any discussion? All those in favor say aye. Aye. Any opposed? All right, that goes on to rules. Next is House Bill 1267. What's the will of the committee? Motion and a second. Any further discussion? All those in favor say aye. Aye. Any opposed? All right, it's going on to rules.
Mr. Chairman, committee members, thank you very much. I think we've made a step forward to unclog our courts and
Oh,
be
wait
fair
a
for
minute.
Georgia.
One thing I left out was Ayla Rakin and Lena Brown. Y'all still want to testify? Sorry about that. I jumped ahead.
Thank you, Mr. Chairman. I am needed upstairs.
Okay, thank you. All right, let's see. And let's see, who was next? Chairman Jaspers, that's right. I knew I had one more that was in a hurry. Come on up, sir. Which one is this?
910.
Oh, there it is. Overlooking it. All right, if you would, go ahead and tell us about your bill.
Thank you, Mr. Chairman. Glad to be here. Thank you for recognizing my chief judge from Jasper, Judge Brenda Weaver, sitting back here. You didn't wave, Judge. Do we see that? There we go. She asked me, Mr. Chairman, a very telling question. She goes, "What trouble are you up to today?"
She knows you well.
And and I appreciate the committee's expertise, and let me bring this bill before you. And I know in this committee nothing's simple. And House Bill 10910, with your help, will make online porn in our state retreat. This came to me from a friend of mine in Jasper, a constituent, and his name is Jeff, and kind of sent this to me back in January, telling me how important it was. He thought I needed to get involved in it and look at it, sent me all kinds of information, and so I became interested in it. And we have a lot of people that help us in this building, but I have an intern this year, Jackson Clyett. He's over here on the window, who has invested a lot of time in this and helped me, senior at Georgia, kind of refine this, get it down to explain it as quickly and easy as I can. But what 910 does, require the users of porn sites to prove they're 18 years or older before accessing the sites that contain 33.3% pornographic material. To meet this requirement, the potential user must show government-issued ID, like a driver's license, to verify their age. And I'll stop real quick. This has been done in a number of states, and this bill specifically looked at Louisiana's bill, which has been very successful in doing this. So that's where my basis is from. A company that violates this law can be sued for damages in civil court, by the parents of those minors who are able to access the site without being verified. This will ensure compliance. The law makes it clear it does not apply to legitimate uses like bona fide news or public interest broadcasts, website, video reports, or events, nor does it affect the right of any news gathering organization. That makes it a non-issue for the age appropriateness. Why? Well, I don't really have to tell you why porn's bad for young people, but I have some supporters who are going to tell you a good bit about that. But two things I just want to bring out. Promotes negative attitudes towards women. And it can and has led to violence, that we know that, and sex trafficking. Yes, these sites have young women who are trafficked worldwide. You know, I've had teachers and parents talk to me after I dropped this bill a few weeks ago, telling the issues they have in their classrooms with young men and women, believe it or not, looking at it while they're trying to do their classwork, because it is addictive. And I was asked yesterday about privacy, wondering if it would lead to collection of sensitive personal information, because we've got to give that ID. And this law protects privacy, that all the information must be deleted upon verification. Additionally, the law only requires you to show government-issued IDs, which are already required for many activities we do, like buying alcohol, tobacco, purchasing guns, ammunition, and even drugs in the pharmacy for me yesterday. I want to point a few out parts of the bill without really going line by line. The first 54 lines are definitions. 55 through 63 allows the public access. The user has to show their ID card of a recognized type. 64, 66, 67, they knowingly publish and fail to perform a reasonable age verification. 68, they're liable, including court costs and reasonable fees. And 72, a $10,000 violation. And 75, they shall not retain ID information, and they're liable if they do so. And there's in 82, there's a list of shalls that does not apply to, Mr. Chairman, I'm glad Jeff asked me about this in January. It's increased my awareness of the issue and what I believe is a rational way to address it. I hope we have prepared well to answer any questions the committee has on this, and we can pass this bill to protect our children.
All right. Thank you for the bill. We do have a couple of questions. Who's got 14 over there? Representative Evans.
Thank you, Mr. Chairman. Mr. Chairman, thank you for the bill. I think it's a good aim. My question is in lines 82 to 85. Why are we excluding the media, and why is it that what are they worried that they need to do that would have them showing porn to 18-year-olds without asking for the ID like we're asking for everybody else? Like, I don't know why they want to exempt themselves from the rules that everybody else has to play by.
Well, I think they don't do that now, ma'am, but I think it's just a safeguard. I was asked, specifically to make sure that we don't grasp in it, that parents aren't going, if they have to show a news report about sex trafficking or all the different things that happen in our world today, that they're not grabbed in it by just showing it briefly on a newscast. That's why it goes through in quite detail back, I believe on line 26, what is defined as material harmful to a child, to a minor. Did that answer your question?
It answers the question as to why it's put in here, but I don't agree, and I wonder why we don't think that lines 36 and 37 would take care of any value that there could possibly be in showing nude body parts on the news, which I don't think they're allowed to do anyway, because I think you've also got rules about that. So if you could answer that question, why does 36 and 37 not take care of it so that we could just take out lines 82 to 85?
I can't, in a reason not to, no ma'am.
Okay, thank you.
Okay. Representative Hong, is that you?
Thank you, Mr. Chair. Thank you, Chairman. Just a clarification question. On line 71 through 74, so you have a fine of up to $10,000, so you're capping the fine to $10,000, but that amount should be determined by the Superior Court. when the civil suit is brought, and then the Attorney General shall institute proceedings to impose such fine within 1 year of the violation. So, are you directing essentially a maximum fine for in capping that fine and having the Attorney General to be the one to bring this proceeding?
I think, I think it's, again, I would always yield to the discretion and wisdom of the court, but just put a maximum on it. No, I mean, would they do the maximum? That's certainly up to them. The Attorney General, I believe, is in there. Maybe someone can even help me with this. Is there, because it's statewide, these entities had a good, I'm out on a ledge into a diving board here on how someone would sue a national, international company, because many of these are.
So are we having the venue as Superior Court in the county where the minor has been affected? Is your intention?
Oh, yes. To make it as easy for the individual who's offended to bring suit would be there in that local county or in that jurisdiction.
Representative Oliver?
We're conferring here, Mr. Chairman. How does this case get to Superior Court? It could be the Attorney General who enforces law, but it could be the family of parents of a minor. And it seems to me that if the parents of a minor are bringing up an action in tort, an injury case, a damages case, are you limiting their right to collect damages, is my question, to the civil fine?
I don't know that answer, ma'am. You're being very kind in your tone and question, and I appreciate it, but this is not in my world.
Well, it's not in my world either, but
Yeah.
Mr. Kelly is going to help you.
Okay, thank you.
The way I read it is there's an option for an individual private right of action in subsection 2, beginning on line 68, and on 71, a civil penalty that could be initiated by the Attorney General and an award of up to $10,000 being awarded by the judge.
Be both.
I think it could be both.
That's the question.
I think it could be. I think it could be both. I didn't see anything linked to that. No, I guess maybe my question is where the collected fine goes to.
Representative Oliver?
Mr. Chairman, we all in this little caucus here support the bill, going to vote for it. We're just trying to figure out whether an individual litigant, plaintiff, parent can seek a civil penalty for the state and damages for their injury done to their child, both. Attorney General can only seek the civil penalty, but does that give the Attorney General exclusive jurisdiction? Is what.
The Attorney General. Sorry, that was my initial.
I got your microphone open.
Thank you. That was my initial concern. Is are we just limiting the civil penalties to the Attorney General and not the individual? I think we can probably have some more clarification on lines 68 through 74 to make sure that we have, even if you're bringing it as an individual civilly, or if it's an Attorney General, you can seek civil penalties, attorney fees, etc.
The way I looked at it is,
I would only add, I'd do both. I'd give the parent the right to do both. That's the question.
the way I kind of imagined it is in 68 through 71, it says is liable to an individual for damages. That's That's what I thought was pretty clear on the private action. But then it says, because then, on line 71, we refer to the up to $10,000 as a fine. And that's what I thought, speaking to damages. No, I think, I thought the way it would work is someone, would make a complaint to the Attorney General, just like you would make a complaint to a DA. And then they have an opportunity to investigate. And if they feel like it's within their discretion, prosecutorial discretion to prosecute, then they would initiate the proceedings within a year. My question would be, should we also allow a local district attorney to have the authority to do this, as well as, I don't think we would have to make it exclusive. I think we could let the Attorney General or a local district attorney have that ability to institute that proceeding.
I agree.
Well, I think the family would make the family can bring a private right of action,
Yeah.
but then the family won't bring the civil penalty. The family would notify law enforcement through the Attorney General or the district attorney for them to conduct an investigation on the civil penalty.
And this doesn't limit bringing both, essentially, because you can do it under this Section 2 as an individual and Section 3 as an Attorney General or DA, if we include that.
That's
you
the
can
way I
have both.
read it, is that it would
I agree,
allow
yeah.
it would allow for both. The judge can assess a civil penalty.
I mean, will the DA, can the DA ask for a civil penalty or only criminal? Judge?
Only criminal.
So that's why the Attorney General is included
Included.
versus a district attorney.
Which I don't think is going to make the district attorneys very happy, but, Chairman Jaspers, let me ask you, what was the intent? Was it to create a crime or to create a civil penalty in your bill?
I believe a civil penalty,
Civil penalty?
Chairman. Yes, sir.
Okay, you weren't looking to make this a crime, just,
To lock him up, no.
right, okay.
That's what I would, would that be the right, not to go to jail, but just a civil penalty?
All right. All right, I got a lot of lights flashing at me here. Let me take care of those. Representative Silcox.
Thank you, Mr. Chairman. I would like to go back to eliminating, lines 39 through 46, because that's the definition first, as well as lines 82 through 86, or 85, because we already have laws that tell the news media how to behave, and I don't think, especially given the fact that we now have proof that a lot of these online places, the iCloud services, have irresponsibly, in my opinion, knowingly put out things that have hurt our young people. I would like to take those exemptions out, as well as the definition of news gathering organization.
All right. When we get to it, we'll call that the Silcox Amendment.
Thank you.
So, all right. Who's got number 4 over here? All right. Representative Hawker.
Thank you, Mr. Chairman. I want to make sure that I understand it. So they have to have age verification, and there's different tools to do that, to include digital licenses, et cetera. But then I guess for a privacy aspect, they're not supposed to retain any of that. And in fact, there's sanctions if they do retain any of it. So how do they prove that they're complying with the law if they have to get rid of all the evidence of proving age to begin with?
I asked the same thing, and because that was my curious representative, and that upon asking, I mean, there'll be a summons or a discovery of information, and if it's not there, it's not there. But I think people will be notified that it is there when they start getting emails, requests for information, use of their information. They would know that the individual or the entity did not dispose of it. Did that answer your question?
I didn't understand what you said.
Okay.
I'm sorry.
I think
Because what I'm driving at is this is all online, right? And so it's a
Right.
massive obligation to retain and restore this data. And my sense is, for better or worse, there's lots of people accessing these sites. So what precisely is the expectation that the state has for the retention of this information? If we are explicitly saying you're not supposed to retain anything showing verification, I just don't understand how they then demonstrate compliance with the law if in fact they are.
I think the way I've got it, my question was, how do you know that they did they get rid of it? And that's the same, I guess, question, is that you wouldn't really know unless you were harmed by the use of that information. Because there's not going to be a website that shows there's nothing there. But if you happen to be or were becoming harmed by the use of your private information that you gave to Pornhub, whoever, you would know it then be able to start a private action on that side of it.
Okay.
Does that make sense? Better?
I'm not sure. I mean, there seems to be an inconsistency between what we're asking them to do. And I don't know how you square it. I'm supportive of what you're trying to do. Of
Thank
course.
you. And I think what has happened, Representative, is that for the providers of porn throughout the country that have been faced with this bill,
Yeah.
they have stopped serving the states that passed this bill because they can't meet that need. They can't. There's some barriers in there that are pretty high for them, and so knowing that, they have withdrawn from the states that have passed this bill.
Yeah. Okay. All right. Thanks.
No. Representative Reeves.
It looks like in Louisiana they have both a civil claim and the government penalties, and maybe it might be a good idea to bifurcate it and have either the parents or representatives of the minor pursue the civil claim, or have the government pursue penalties. And if it's not a felony, one thought is add solicitors to that list. If we're going to add district attorneys, add solicitors also in addition to the attorney general. That way we have multiple agencies who are empowered to investigate these crimes, just like we do with nuisance and other harmful things in the community. And I noticed the Louisiana law and several other states' law have been approved by federal courts. So, you brought a good bill in a good area, but I think sort of splitting the civil and the criminal, or the government action versus the private action might be a good idea.
Okay.
We can do it here on the fly. We can certainly give it a try, but I think that's the way they're doing it in Louisiana. They have either the government or the private action.
Okay.
Well, not criminal, but the government can pursue fines. The state of Louisiana pursues fines, or the parents can have a private right of action in
Okay.
Louisiana, so it's separated out.
Okay.
The government wouldn't give the money to the parents. No, I think we ought to do both, and that's what they're doing in Louisiana, but I think making that clearer in the bill and adding multiple agencies to it, solicitor, DA, in addition to attorney generals.
Okay.
Those are some ideas.
Representative Evans.
Thank you, Mr. Chairman. Mr. Chairman, to the point that Representative Reeves and several over here were making earlier, I wanted to just ask in advance of us getting into the committee discussion, if we were to add on line 73, the Attorney General or District Attorney having jurisdiction, whether you would be okay with the addition of that, and then perhaps at the end of that subsection, a sentence that says the issuance of a fine under this section does not preclude a right of action under D2. So that way it's clear that you have both.
Sure.
You'd be fine with that.
Absolutely.
Okay. Great.
Y'all know your business.
Okay.
Yes.
Just want to make sure it meets your intent, because I think the intent's good.
I believe it does.
Yeah.
Yes, ma'am.
Okay, thank you.
Okay. All right. Call that the Evans amendment. All right. Well, that's all the questions I see right now. and I'm gonna call up some folks that want to testify on this. Brooke Mills. Is there a Brooke Mills here? No? All right. Sarah Hunt Blackwell.
Good afternoon.
Good afternoon.
All right. Good afternoon, Chairman and members of the committee. My name is Sarah Hunt Blackwell. I'm the First Amendment policy advocate with the ACLU of Georgia. The ACLU of Georgia has many concerns about HB 910 and the age verification requirement. First, the language of the bill is extremely vague. The bill places age verification responsibility on commercial entities, but doesn't specify what is considered a commercial entity. While the bill sponsor has verbalized the intent of this bill to target pornographic websites, using the term commercial entities could impose the requirement beyond those sites. In fact, social media websites could fall under this requirement because they arguably feature at least 33% of harmful content for minors. In fact, statistics show that pornographic content is rising on social media platforms. Another vague term in this bill is reasonable age verification. Reasonable according to whom? Reasonable as defined by what? Would the verification be reasonable if a minor uses fake documents to access one of these sites? Age verification methods vary, and what's considered reasonable in one context may not be considered reasonable in another. On the topic of age verification methods, most of them are intrusive and jeopardize privacy rights. The current language of the bill does not provide enough clarity as to which methods can be used or what type of verification would be valid. Most age verification sites and apps require scanning or uploading of government-issued documents such as driver's licenses or passports. This is highly sensitive information that should not be uploaded for websites or third-party companies to access. Even though HB 910 includes language preventing retention of this sensitive information, it does not include language preventing the information from being sold or redistributed. What is most concerning about all of this is that it becomes a requirement for all website users, not just youth. The aim of the bill is to shield minors from this content, but it requires everyone who visits the website to upload sensitive information to verify their age. We understand that the internet is a limitless space where content, specifically pornographic content, is easy to access. But this bill is not the solution. It subjects the entities to legal liability despite vague language, and it infringes on the privacy rights of every individual who accesses these websites. As such, we ask the committee to please reconsider the requirements of this bill. Thank you.
Representative Holcomb.
Thank you, Mr. Chairman. Are you aware of any examples where the states have been able to achieve this in a way that addresses your concerns? In other words, a different model from this?
No. Well, age verification in general is problematic for these privacy reasons. And to my knowledge, I'm not aware of any states that have been able to kind of pass these protections without an age verification requirement.
Okay, thanks.
Okay. Representative Evans.
Thank you, Mr. Chairman. My question is along the lines of Representative Holcomb, but specifically on lines 14 to 15. I don't know if you have the bill in front of you. Really the definition of commercial entity. Mm-hmm. Is there any suggestions that you have on how we can make that less vague? I was thinking perhaps adding language that makes clear that this entity receives some kind of money for what they do, but I'm having trouble coming up with language. I didn't know if you'd ever seen any or had any thoughts on that.
Well, I think that if the bill is aimed at targeting pornographic websites specifically, that there can be language included that says that. I think that there's a difference between, even with the social media websites, there's a difference between websites that are that exist for the purpose of people just accessing them and websites that exist for the purpose of accessing pornographic content. In the same way, I think about websites for like liquor and alcoholic beverages. Like you have to kind of, once you go to those websites, you have to say, yes, check a box that says, yes, I'm 21 years old to access these websites. So kind of situating it in that same type of framework and adding some language that specifies that what we're talking about here are really pornographic websites.
Okay. Thank you.
Representative Oliver.
It's the privacy concern that how can you be barred from retaining personal identification but also sell it? That seems inconsistent.
Well, depending on, again, this is an issue, a concern that we have, because depending on the third party that the website uses, or the app or the website that's used for age verification, there's a possibility that even with that information could automatically be redistributed or automatically be sold to another third party under a contract that third party company has with another third party.
Okay. All right. That's all the questions. Thank you.
Thank you.
Let's see. Karen Dial.
Yes, thank
If you would introduce yourself, and
Yes.
if you represent anybody, let us know.
Oh, no, it's just me from Flowery Branch.
All right.
My name is Karen Dial. I am from Flowery Branch, and I would like to thank Chairman Stan Gunter and the other members of this committee for hearing my testimony. I want to thank Representative Sue Hong for encouraging me to testify at the Red Ropes. I support the age verification bill for pornographic websites. The next few minutes of my testimony are very, very important to me. I am a mom and a grandmother and a high school teacher. But today I see myself as defending Georgia's kids against a giant billion-dollar industry that has sexually harmed our children. I first learned of childhood addiction to pornography when one of my students told me and the entire class that he had been addicted to internet pornography from the age of 7 until the age of 9. I was shocked. But what exactly was he addicted to? My idea of pornography at the time was the photograph of a nude woman. Not long after this, a family friend found rape porn on her boyfriend's phone. Rape porn? Was that even legal? Is that hard to obtain? So I started my research journey. I got an education in the violent reality of internet porn, the widespread viewing by children, and the horrific effects on a child's behavior. First, hardcore pornography is now mainstream pornography. Well, what will a child see? Well, one researcher found that 88% of popular videos contain violent gagging, choking, and slapping during the sex act. The woman's body is penetrated and pounded in her vagina, anus, and mouth, sometimes more than one penis or even a fist. In the end, the man often ejaculates on her face. This is mainstream pornography. And the storylines? Let me describe the 3 top genres. Rape porn. The violent rape is acted out and the woman smiles like she liked it in the end. Incest porn. Sisters and daughters become the rape victims. And teen porn. Young women who look like little teen girls are put in horrifying sexual scenes. And this is the most popular genre on the internet, yielding over 3 billion results. So, how many kids are being instructed by hardcore pornography? The average age that a child sees porn is 10, and many, like my student, are much younger. Let's imagine the reality of a 7-year-old watching rape porn, or even gang rape porn. That's just another click away. How many kids watch it? One researcher says that 90% of American teens have seen porn. Finally, if the scope is this large, we should expect to see changes in the behavior of children. I have attended 3 conferences in Washington, D.C. of experts concerned with this crisis. What was one of the main topics there? The significant rise in child-on-child sexual abuse seen by school teachers and hospital nurses. Many experts claim that children are attempting to act out violent pornography on other children. The National Center of Sexual Exploitation in D.C. has many of these testimonies on their files. So, what if you pass this bill? A little boy like my student now faces a barrier that he cannot cross into a world of violent porn that he cannot control. He is finally protected. Thanks so much for hearing this difficult testimony. I appreciate you. I know you don't often hear this graphic descriptions, but I want you to know it has been a duty and an honor to share my heart with you today. Thank you. Thank you. Oh, I'm sorry. Do I have to stay for?
I don't see any questions, so thank you.
All right. Thank you. Thank you.
Chelsea Thompson?
Good afternoon, Mr. Chairman, members of the committee. So this is my first time testifying actually before the Georgia legislature, and I'm kind of tempted to come up here and say Chief Justice, may it please the court, but I will refrain from that. So my name is Chelsea Thompson, and I am General Counsel for Frontline Policy. And I first want to thank the sponsor, Chairman Jaspers, for bringing this very necessary and important piece of legislation requiring age verification for material harmful to minors online. So I'm here to share support for our support for this bill, and to also advocate for the importance of this legislation that protects children from accessing such material, as well as the significant impact that this could have on our Georgia adolescents and our society. So some important points as a whole: harmful to minors laws generally seek to protect minors from pornography, obscenity, and other such material that may bring harm to them. With the rise of technology, minors currently have nearly unlimited access to adult websites, many of which contain inappropriate and pornographic material. Studies show that by age 17, about 75% of adolescents have been exposed to pornography, and this statistic, while it's quite alarming, is made possible by the fact that many of these websites are accessible without parent permission through age verification. So to provide a little context and more statistics as well, most kids today are exposed to such material between the ages of 10 and 13, with 84% of males and 57% of females ages 14 to 18 having viewed such material. 73% of teens reported that they have consumed pornography. At least 1 in 3 of pornographic videos have or show and contain sexual violence or aggression. Porn titles shown to first-time users on porn site homepages describe acts of sexual violence themselves. Over half of 11 to 16-year-old boys and over a third of 11 to 16-year-old girls have reported and believed that pornography was a realistic depiction of sex to them. 58% of teens have stumbled across pornography accidentally, which this bill's requirement of age verification would substantially limit this. And 71% of teens have done something to hide their online activity from their parents. So this bill also helps put parents back in their rightful place of controlling whether and how their children engage with dangerous pornographic material online. Parent oversight is already required for a variety of things, including liability waivers and contracts, and it should be necessary in decisions relating to children's exposure to pornography as well. Some powerful reasons why it matters, because these are extremely harmful, some powerful reasons why it matters are extremely harmful effects of pornography material alike. Not to mention that exploitation and trafficking, as others have mentioned, are common experiences in the porn industry as well, and this is being shown and promoted to our youth. So to touch on some of the harm, consumption of such material has been linked, and there are studies out there, several studies, that show there's an increased loneliness, a lack of self-control, depression, stress, anxiety, lack of confidence, ADHD, poor body image, lower self-esteem, psychological distress, aggression, feeling objectified, racism, various sexual and non-sexual functional impairments, development of eating disorder symptoms, misogynistic thinking, and a diminished view of women's competence, morality, and humanity, among many other issues that have been mentioned today. Experts have also determined that 4 major brain changes common to addicted brains can all be found in cases of pornography consumption as well. And this is why we need this bill to protect our Georgia minors from such negative influence and mental, physical, and emotional harm. Some have argued against these measures, claiming that the government should stay out of matters relating to children's online access and that a decision ultimately belongs to the parents. And we wholeheartedly affirm that decisions pertaining to a child's time online belong to parents, and this is why we strongly urge you to support this bill. The age verification requirements will place these choices and others back into the hands of parents across Georgia. In our current Georgia code, we already have protections, I'm sure you all know, and limitations in our Georgia code addressing this issue in regard to sale or distribution of material harmful to minors. This bill, I would argue, it expands that intent to protect adolescents from such content by online providers that allow access of this material to minors. As Chairman Jaspers, I think, touched on, Louisiana did pass the first bill, kind of started this movement, I think, back in 2022, I believe it was, HB 142. And eight states have passed so far this legislation related to porn age verification. And currently there are 49 bills across the nation in 2024 across 50 states. So, and 2 of which are in Congress, which if you've kept up a little bit, one's the Screen Act. Anyway, in 2022, when Louisiana passed HB 142, sorry, I don't know if I come close. When Louisiana passed HB 142, Pornhub implemented the system, and it saw traffic from Louisiana dropped by 80%. That is significant. Now, Utah, Virginia, North Carolina, Montana, Mississippi, Arkansas, Texas are the other states that have passed similar legislation. And Pornhub has since pulled out of all of these states. Supreme Court's made it clear that there is a legitimate government obligation to protect children. And the United States Supreme Court has recognized the scope of this obligation and held that there is a compelling interest in protecting the physical and psychological well-being of minors. And this interest even extends to shielding minors from content that may not even be obscene by adult standards. The government may serve this legitimate interest as well to withstand the constitutional scrutiny. It must do so, obviously, by narrowly drawn regulations. We would argue that the carefully tailored means here is the easy age verification step. In conclusion, porn use is affecting individuals' emotional, physical, and mental health. And this is why we need this bill to help protect our Georgia minors from such harmful material and help break the cycle of commercial sexual exploitation and the damage that the industry creates among our children. And as a result of these things, I'm asking the committee and you, Mr. Chairman, to vote yes on House Bill 910. I would also like to add Mike Griffin from Georgia Baptist. He could not be here, and he said that he would like to offer his support for the bill. In addition, in your packets, you'll see a document, a letter of support from Joe Combe. He's the director of public policy for Family Policy Alliance, and he also offered his support of the bill.
All right, Representative Bruce.
I definitely appreciate the need to protect the children, but I'm just curious, how is this monitored? How does one determine that this is happening in somebody's house or wherever? How is that known? I guess because I'm trying to figure out what other access to information, whoever that is looking at this, what else can they see on my computer or somebody's computer at home? You understand my question? I just don't understand how you monitor it.
I'll just add, Representative, I don't know that you monitor it, but what you do with this bill is prevent it.
Well,
you're creating a barrier between a child in your home's ability to gain access to the porn site by age verification.
I mean, but age verification can be falsified. I mean, it's done all the time. Every day somebody's falsifying information. And if somebody's sitting at home and you're asking them to give some sort of identification, they could make up identification. I'm just trying to understand how you monitor it.
I don't know if I can. I don't know that you can make up. The bill's pretty clear on what the appropriate identification methods are, and even to go so far as to delve into U.S. Commerce definitions of what age verification are, and that's pretty in depth. I mean, and not just a simple, I'm 18, I'm Rick. I think it defines that pretty well, if that answers.
Okay. I don't want to make it, I'm just.
Yeah.
Real quick,
Sure.
I would add, if I may, that I think Chairman Jaspers touched on it, that I don't believe that's the intent of this bill is not to monitor, but it's more so to prevent access to it. So the monitoring aspect obviously wouldn't fall, so much under this bill. And then there, underneath sections, if you look, lines 58 and 63, kind of lays out the methods for age verification there. So obviously the hope is that those methods laid out would prevent any type of fraud, right, or impersonation. So.
Okay. Thank you.
Representative Silcox, you're 16. Go ahead.
Yes. Thank you, Mr. Chairman. Thank you so much for your testimony. It's really heartbreaking to hear those statistics, and I so appreciate the bill. I am concerned about these third parties selling the information, this sensitive information. In any of the other states, do you know if they have tighter language around not selling the information? Do you know if there's any? Because, I mean, breaches are every day, right?
Right.
And the last thing you need is for a child or a young adult to go on there legitimately, not being a minor, but their identity is compromised because they submitted their age verification.
Right. So there is some language that's a model that's come down from federal organization that I can share with Chairman Jaspers if the committee would like to review, that could tighten up some of this. But it's kind of, I mean, I was talking actually back there with the lady from ACLU, and it's like, even if we put a provision in the bill that states something like, the entity shall provide proof, right, that they didn't retain or sell, et cetera, right, then that gets into like regs, and it could draw it out, right? So, but I'm happy to look more into it, or I can provide what I do have to Chairman Jaspers to
Okay, thank you.
disperse.
Is the language of the Louisiana bill similar to what we have in front of us?
Yes. Yes, sir. Yes, sir.
is.
Just the only changes, Chairman, were made Legislative Council, just the numbers and ideas. The idea is exactly the same.
Okay. All right. That's all the questions. Thank you.
Okay, thank you. Thank you.
Anybody else here to testify on House Bill 910? All right. Discussion by the committee. Got a motion? Do I hear a second? Second. Got a motion and a second. Any further discussion before we vote? Yeah, well,
That's a great echo.
who's 14? Representative Evans?
Thank you, Mr. Chairman. Just to make the amendment that we had previewed. We did that. Yeah, we did motion in a second.
Silcox or Evans amendment?
Do you want to go first? They're two different amendments. So, the amendment I would offer would be on line 73 after the word Attorney General to insert or District Attorney having jurisdiction, and at the end of line 74 to add the sentence, the issuance of a fine under this section does not preclude a right of action under D2.
Second.
Okay. The issuance of a fine does not preclude under this code section, is that what you said?
Yeah, that at the end of line 74 would add the issuance of a fine under this section does not preclude a right of action under D2, subsection D2, if it needs to say that.
Okay. All right. You got it?
Yes.
All right, I have a motion and a second on that amendment. Any further discussion? Representative Reeves.
Representative Evans, would it be a friendly amendment to add solicitor to district attorney?
Sure.
I so move.
Second.
Motion and second for that friendly amendment to the
Mr.
amendment.
Chairman, we actually think that it should be, that sentence that we added at the line of, end of line 74 should refer to C2 instead of D2.
Okay.
That's the Kelly.
Without objection, we'll take that change. All right. Any further discussion of the Evans amendment? All those in favor, say aye.
Aye.
Any opposed? All right, that one's in. Now, Representative Silcox, you want to do yours?
Thank you, Mr. Chairman. I'd like to remove lines 39 through 46. And then as well on lines 82 through 85.
Okay.
Second.
All right, have a motion. Yes, sir.
Can I just ask a question?
Which, you 15?
Yeah, I don't think my button works. I was looking at I'm trying to figure out with the cloud service providers, a lot of times they're just hosts, I think, who don't necessarily know what the product is. And that's the one question I have is do the cloud service providers, are they the same? And then I don't know, should they be treated the same as a news gathering organization or a broadcast? Because I understand people who are disseminating information, but I wonder if there's a difference between the people who are disseminating the information versus the people whose servers it's just running across and may not know. I don't. That's just the only question I have is I don't know. And so my only question is whether 85 should be left in or not. What I would just ask.
They got mine.
You could strike 83 and 84 and leave 82 and 85, but I don't know. I'm just asking. I don't know enough about the cloud service.
Just to try to address the concern, I personally understand that concern, but I think it's taken care of because in order to come under this, you've got to have, I think it is 33.33% of the total material being this material that's harmful to minors. And then also another problem, I think, with having iCloud or cloud service providers in here at all is that it's not defined. So I get the concern, but I think with that 33%, we're probably not going to put anybody's, cloud storage pictures in jeopardy.
Yeah, that was just a question.
Yeah.
Yeah.
And you wouldn't be accessing, I don't think you would be accessing anybody else's cloud storage except your own, and you'd have a password for it.
Okay.
Yeah.
All right.
Representative Hong? No? Wave? All right. I'm sorry.
I don't have it.
Nothing? All right. Okay, I believe I have a motion. I don't have a second yet on the Silcox amendment. All right, but any discussion about a change to that amendment, an amendment to the amendment? Okay. All those in favor say aye. Aye. Any opposed? All right. Got the Silcox amendment, got the Evans amendment. We had earlier in the discussion about lines 14 and 15, commercial entity, and I was wondering if sticking at the end of it, do away with the period and say that deals, I put primarily in pornographic material, but you may want to use a different word than primarily.
So that was something that I was going to suggest, but I think substantial portion covers that.
Okay. 52. Okay.
So I don't think it's necessary because line 32 covers 52.
Okay. Maybe so. All right, are we ready to vote on the bill? All right, I have a motion and a second, and the amended bill with the Silcox amendment and the Evans amendment. All those in favor say aye. Aye. Any opposed? All right, bill goes to rules.
Well, I just would like to say thank you for your deliberative thoughts on this. My first time here, Mr. Chairman. appreciate the thought. And
Wait a minute, whoa, first time here? How many years
It
you been?
is. I testified in a judiciary hearing many years ago, but I've never done my own thing here.
Oh,
Of all the different bills that I've done, I've just had, but it was just great, and I appreciate all of y'all's input.
well, thank you for bringing the bill.
Thank you.
So, Matt, your bill? Or are you going? Let's see. I'll see what I can do with whatever else I have on today.
The rest of the bills are Leverett's bills.
Oh, they're all Leverett, and he's not here.
He's here for that. Okay, yeah.
Okay, sorry. All right, Representative Reeves, if you would tell us about House Bill 1240. I've got LC 560106. Is that correct?
All right. I'm looking for the full screen on here.
Hit slideshow.
Let's see.
He's
There we
talking
go.
about.
Okay. There we go. There we go. All right. Sorry about that. This is the Georgia UCC update. The last one was done in 2001. So House Bill 1240 is once in a generation opportunity to brush up on Georgia UCC law. I did not know that the PowerPoint was going to be copied for you, so that'll abbreviate the PowerPoint presentation since you already have it, and I'm sure have been reading it with enthusiasm and curiosity. I'd like to acknowledge Kathleen Curry and Thomas Powell for the deep dive on this bill. They're here today to answer any questions that you have. We're working on LC 560106 as well as an amendment, AM 560001, that are in your packet. So just to give an overview of the UCC update, ALI, Uniform Law Commission, started about 2018 in a 4-year project to update and modernize the UCC, and they had experts from all around the country work on that. Georgia, the State Bar's Business Law Committee, UCC subcommittee worked on it with a number of law firms in Atlanta who were named on there. In addition to the Parker Hudson attorneys I mentioned earlier, you've got Baker Donaldson, McGuire Woods, Denton's, Burr and Foreman, Brian Cave, and you had a UCC and bankruptcy professor, Professor Simon, who's taught at both UGA and Emory, work on the project. And again, this is a State Bar committee that has gone through the process at the committee level as well as State Bar Legislative Committee. 2001 was the last major update. Representative Kelly mentioned he made an amendment at some point along the way, and substantive parts of the UCC generally are not affected. This is an update and a modernization to take into account that we've got, a digital age. Back in 2001, the iPhone, would not come along for another almost 8 years. So this catches up with things like electronic deposits of checks and the technology that we've all come to use since 2001. The bill does go into effect July 1st of this year if passed, but there will be a 1-year grace period for security interest and amendment of documents after that. The other states who have adopted it are around 10 at this point. You've got several other states considering it this year, and many others have processes underway. Our State Bar has done this quickly, and we're ahead of the curve on several states. I'm going to come back to the digital assets portion because I think there are some more straightforward ones. On negotiable instruments, that's something that might be more familiar. Remote deposit of checks, that's something that I think most folks have encountered, and Article 3 is updated regarding that issue. They don't provide for electronic negotiable instrument transfer instrument under Article 3. Article 4A is amended to update provisions regarding security procedures for funds transferred. So a lot of what this is doing is defining under the law a lot of things that are already going on but are not well defined under the UCC. And just to step back for a minute, the UCC is about private transactions and security interest on things other than real estate. So personal property, equipment, the many transactions that we have going on at Georgia, whether it's at the port or small business on Buford Highway or around the airport. This covers that, and it makes sure that if you loan money on equipment, it's secure, and it makes sure that Georgia law has caught up with all the technology that is in place that is on the horizon. Sales and leases of goods. This is updated to address hybrid transactions where you have both a sale and lease of goods and a service component in there, which has become more frequent over the last generation. Article 2A and 2 is updated. And then here are some things that are a little bit more straightforward. Writing is redefined to record because back in 2001 you had a lot of written documents. Now you have a lot more electronic transactions. People are paying their bills electronically, making deposits electronically, so you have a lot more records than you do writings. The word signed is expanded to include an electronic signature. Conspicuousness and things dealing with checks, that's updated and modernized. The definition of person specifically includes LLCs and corporate entities. You have updated definitions in Article 1, and you clarify the governing law regarding letters of credit, and the definition of control in Article 7 is expanded to include electronic chattel paper. Article 9, authentication, is replaced with signing. And Article 9, a signer and assignee language is clarified to include electronic technology. So there are some amendments regarding security interests in commercial tort claims to reflect a lot of the transactions that are going on in that area. And again, the effective date will be July 1st. However, you'll have a year until July 1st, 2025 to have your existing perfected security interest updated in light of the new law, and your enforceability is protected in terms of the year grace period to catch up with the new law. Going back to the electronic money, just to address that, and digital assets, the amendment makes it clear this is not about any sort of a move for government to establish a national digital currency. That's something that the lender community brought forward that idea. Several of the other states have put that in there. That is not what the UCC is about. This is about private transactions and making sure the law and security interests are well established regarding private transactions. So you do have some amendments about digital assets and controllable electronic records. Again, this provides law in an area right now where there's not a lot of law, but there are a lot of transactions going on in Georgia and on the internet. So it does give broad enough digital and electronic language to apply to future technologies that might develop over the next 20 years between now and when we have the next 115-page bill come in front of this committee one day, and it will accommodate the known technologies and some that have yet to be invented. Digital assets will be covered, but again, it doesn't require or in any way incentivize that. It just makes security interests safe regarding transactions, those private transactions. With that, I would yield, and we do have the two representatives of the State Bar's Business Law Committee, UCC Subcommittee, who helped author the summary, who are here to answer detailed questions. I'd be glad to answer any questions you have, and would ask for a motion to do pass this update for the first time since 2001.
I don't see any questions. So we do have Kathleen Curry and Thomas Powell, would y'all like to come up?
And they are here to answer any questions that you have, the detailed legal nature, if you have any, but, with that, we present the bill to you.
Representative Silcox.
Just for fun, since the UC is so exciting, I thought I'd ask, as lenders, would there be something active that, under this new law, the lenders would have to do to perfect a security interest they might hold, that would need addressing?
So, not that they have to do, but they might want to do. So, to maintain priority, if you have an electronic record, you will now be able to perfect by control, not just treating it like a general intangible or an account, where you perfect by filing a UCC. So you have that option to file by control, and that would be take priority over a filing by a UCC financing statement. And so that's why there's this transition period, so that lenders will have a period of time to take control if that's what they elect to do. And I do think lenders probably will want to amend some of their loan documents to further expand like rules around that control. So Thomas and I have both been thinking about kind of what that would look like. But the actual grant of security would not change. So a controllable electronic record and a controllable payment intangible would still be a general intangible, so you can perfect by filing. A controllable payment right could be an account that you could still perfect by filing. So it's not nearly the same disruption that we had in 2001 with those amendments.
And Representative Silcox, I would add that the lending community who monitors legislation at the Capitol has reviewed this lengthy bill. The amendment AM 56001 was the only amendment they had, and they're prepared to educate their lenders on this new bill. And I would encourage everybody, look at your security interest between July 1st, 2024 and 2025.
Okay, great.
Yeah, it gives more certainty. It's a good thing that both sides, it's better for both sides, I think, because it gives more certainty and into, how you can have that first priority security interest and grant it and be able to use it as security to borrow money. So I think it's actually very positive.
Very good. Thank you.
That's all the questions I have. Anything else y'all want to tell us? While I got you, I don't know.
I think you've been here long enough.
Thank you all.
As long as I don't have to retake the bar and take this again. So. All right. Got a motion to pass. I have a second. Any further discussion? Oh, we got the amendment. That's right. What do I do with that? Here we go. In your packet is an amendment, AM 560001. Do I have a motion on the amendment?
Second.
Motion and a second. Any further discussion of that amendment? All right. All those in favor of the amendment, say aye. Aye. Any opposed? Now we're on to the bill. Any further discussion? All those in favor of the bill, say aye. Aye. Any opposed? All right. Bill goes to rules.
Thank you.
Thank you.
Thanks a lot.
Thank you so much.
Thank you, Matt.
Okay, we're going to take a break until we get Robert Leverett here. He's got 4 bills on the calendar for the afternoon, so we're going to wait on him.